Ready? Start. The present appeals arise from a partnership dispute in which appellant claims entry into the firm by virtue of a document whose execution is stoutly denied and is alleged to be forged. Stop. The High Court, on the same factual foundation involving the same alleged arbitration agreement, has in one proceeding directed the parties to resolve their disputes through arbitration, and whereas in another proceeding, declined to appoint an arbitrator on the ground, that the existence of an arbitration agreement is itself in serious doubt. Stop. A common issue, namely, whether the disputes can be referred to arbitration or an arbitrator can be appointed when the very existence of arbitration agreement itself is seriously disputed on the allegations of forgery and fabrication, arises for consideration. In these appeals, the appellant, on 16/5/2018, filed a civil suit bearing number 71 of 2018 before the competent civil court seeking the relief of declaration and injunction against the respondent number 1, inter alia seeking a declaration that the admission deed is a forged document. Stop. The respondent number 1, in the said suit, preferred an application to the trial court under section 8 of the act, to refer the suit to arbitration, owing to the existence of an arbitration agreement between the parties in respect of disputes concerning the admission deed. Stop. While findings in section 9 proceedings are undoubtedly prima facie in nature, such findings, when they attain finality, cannot be ignored in subsequent proceedings founded on the very same issue. Stop. The prima facie satisfaction recorded by the High Court regarding the doubtful existence of the arbitration agreement was, therefore, a relevant consideration while examining applications under sections 8 and 11 of the Act. Stop. The cumulative effect of the aforesaid circumstances lends considerable credence to contention of the appellant that the admission deed is not genuine. Stop. At the very least, the admission deed is under grave cloud of doubt, requiring a detailed and full-fledged inquiry. Stop. In the present case, arbitration clause does not exist independently but is embedded in the document whose existence is seriously disputed. Stop. Arbitration, it bears reiteration, is founded upon consent. Stop. A party may be bound by the arbitral process only if it is first shown, even at a prima facie level, that such a party had agreed to submit disputes to arbitration. Stop. Where the arbitration agreement itself is alleged to be forged or fabricated, the disputes cease to be merely contractual and strike at the very root of arbitral jurisdiction.